All right, everybody, welcome. Justice is a Process is here, and we are here to review the case of Jennifer Crumbley because it has finally made it to the point, my favorite time, and that is closing arguments are done, and the case is about to get handed off to the jury. And this is going to happen on Monday. And of course, the judge is still going to have to charge the jury, meaning they're going to be read the law, and then they're going to get to settle back and deliberate. So you saw the headline. I'm making a pretty bold statement here where I am predicting a not guilty verdict in this case. I believe Jennifer Crumbley will be found not guilty in this case. Now, there's a lot of people out there that think this jury is going to go off of emotion, and they think that she's going to be convicted. However, I believe, because I believe strongly in the jury system, and I believe jurors take their role very, very seriously, I believe this jury is going to follow the law, and this jury is going to find Jennifer Crumbley not guilty. So we're going to get back. We're going to look at a few clips here. We're going to go through the state's closing argument slides, which we look at the case, and I'm going to explain to you why I believe Jennifer Crumbley should be found not guilty and is not guilty of the charges of involuntary manslaughter. I'm also going to play a couple of important clips of her attorney's closing argument because I think her attorney did a fantastic job closing. And now, obviously there's a lot of mixed sentiments out there about her performance, but I think, during the trial, but I think if you followed the closing arguments, if you followed the message in the closing arguments, you understood that what she was doing in this trial was a strategy, in my opinion. And that strategy was an all-encompassing strategy. And it basically went like this. Jennifer Crumbley is a normal person with flaws. She makes mistakes. She's human. But she's not a individual who committed gross negligence in this instance. And the state is attempting to take a normal individual who has flaws, who isn't perfect, and they're trying to stretch those imperfections, vilify her, and punish her because there's a kind of a bloodthirstiness, bloodlust out there for holding people accountable because of the horribleness of what occurred in that school. And that the state rushed to judgment here, that the police felt like they had a situation here that was worse than what it turned out to be, that the machine had started moving in the direction of Jennifer Crumbley with a particular storyline, and once it started moving in that direction, it just started moving downhill right towards Jennifer Crumbley. And what I would have liked to have seen her touch on, because I really think, in my opinion, and I posted up the interrogation video for everyone to see. I did that on purpose because I believe it was in that interrogation room, that the police decided they were going to be targeting the Crumbleys. And I believe it had everything to do with the fact that they asserted their rights. One thing that police officers don't like is when people assert their rights, when they refuse to talk to them and cooperate with them. And if you notice, within moments of sitting in that room, Jennifer Crumbley asked and said she wanted to have an attorney. She stopped her husband from talking. Her husband said he wanted an attorney. They wanted them to waive Ethan's rights so that he could speak with them, and they refused to do so and said he was getting an attorney. Police explained their position, that they wanted to have the ability to talk to him, understand why, that it was, for all practical purposes, just a formality here, that there wasn't a true situation here where he was going to be having a defense. But they said, no, we want a lawyer. And in my opinion, that act in and of itself stands out to me as the first indication of what type of parents the Crumbleys were. If you're going to sit here and make a case that these were negligent parents, so negligent that they ignored the warning signs of their son's mental health, that, and that they cared so little about him, um, then why would they be standing up for him and saying, no, we're getting him an attorney. He needs to have an attorney present. And we want to make sure this is done right. We want to make sure he is protected. That's the first image that we see. To me, that's the most important image. And if there's ever evidence of the protective mother that Jennifer Crumbley was, it's in that moment when she goes right into protection mode and she does what every parent should do in that situation. Even though it's pretty clear her son is going to be more likely than not going to jail for the rest of his life, at that point, it's not clear what's happened. It's not clear whether anyone's actually died. And as she said, in her mind, she didn't know the full extent of anything at that time. Police officers at that time were telling her no one had yet died. There was not a declared fatality at that point. In her mind, there were still things that could be worked through. And she goes immediately into protection mode for Ethan. It wasn't that she said, hey, if she was this truly neglectful mother, what you would have seen would have been that selfishness that the state is alleging was present in her life. And that is that she would have asserted herself and said, I want a lawyer before I talk, but that's fine. I'll waive my son's rights. You talk to him. You get what you need out of him. I don't care about him. But that's not what she did. So in my opinion, that was a missed opportunity by the defense attorney to have pointed out that right there, that act, the act of asserting his rights, refusing to waive those rights, and declaring that they were going to be getting Ethan an attorney and that they didn't want him speaking with the police until an attorney was present, demonstrates she is a protective mother. In fact, she's a vigilant mother right there in the police station. And it was that act, in my opinion, that led to the police deciding, you know what, you're not with us, you're against us. And within 2 hours, they have the police at their house. And who's in handcuffs? Not Mr. Crumbley, but Jennifer Crumbley. And why is she in handcuffs? Because in that police video, she is the one, if you go back and you watch it, it's on my channel, she is the one that jumped in and said, no, we need an attorney. And they didn't like her attitude. They didn't like her not helping. So they said, all right, lady, you want to be against us? We'll do a show of force. We're coming in, we're serving a search warrant, and we're going to put you in handcuffs. We're going to put you in the back of a car. You're going to be in the back of a police car, and we're going to let you know what it means when you don't cooperate with the police. I believe 110% that's exactly what was happening there. And in their opinion, they felt like this was not a time that you asked for your son to have an attorney present, and you deny us the ability to have a conversation and figure out what's going on. So I believe from that moment on, everything was being looked at in a way to say, how can we punish these people? How can we go after them? How can we prove that they were, neglectful parents? And the culmination is, of course, we're going to take a look at this case, a case that is just, for many people that are aware of how this process works, everyone says when you apply the law in this case, it's crazy. It's not guilty. The state didn't have a case, but the state has gone out of its way, as was pointed out by her attorney in closing arguments, to bring in the most prejudicial and inflammatory evidence that they could to try to upset this jury and pry on their emotions. So we're going to take the emotion out of it. We're going to go through the state's case. I'm going to play a few clips from the defense. I'm going to make the case to you why I believe this jury will come back with a not guilty verdict if they follow the law. I believe they're going to do that. I believe this jury, after saw what I saw, and I believe with the culture in that community, it being that it is a gun-friendly culture, I don't think they're going to take too kindly to these prosecutors' approach and judgments and idea that just because you own guns, just because you're a gun-owning family, that somehow you're going to be an irresponsible parent. Because essentially that's what they're throwing out there. Because Jennifer Crumbley didn't own the guns. She wasn't responsible for the guns. She was just in the household with a gun-owning husband and a son that had an interest in firearms. And the assumption here is that anybody who is a firearm owner should assume that their child could be the next school shooter. And I think that these people will take umbrage with that. Now, again, I wasn't present for jury selection. I didn't get to see jury selection. Michigan doesn't have the open documents and record rules like Florida does, where you can go right in and look at things. I haven't been able to see the documents and stuff on this process so far. I'm blindly operating here, but I'm making an assumption that Shannon Smith, who is a very, very good defense attorney, that she did a good job selecting this jury, and that she found jurors that she felt were going to be helpful to her case. And she was presenting a case in a very strategic way. She was presenting her emotions in a strategic way. And she did all of this and wrapped it up in a nice little bow and presented her closing argument in what I thought was a very effective closing that I believe will resonate with that jury. And they've had an entire weekend to consider it. I think that there could be one or two people that maybe aren't ready to roll right into a not guilty verdict. But I think that within a couple of hours, we're going to be at a not guilty on all counts. That's my belief. I could be wrong, but I really do believe that. And we're going to talk about why I believe that is, and, get into that. So let's jump into the case review here. But the state went into, and to understand this case as we're going through the witnesses and we're going through the summary of what was presented, it's important we understand what we're looking for. So the state has explained, and the judge will explain this on Monday, there's two ways to which there's two theories of the case that the jury can find, and they explained the jurors do not have to agree on the theory. So 6 jurors could agree on one side of this sheet, 6 jurors could be on the other side, but as long as they agree that in one of these two ways the elements were met, then they can proceed with a guilty verdict. So gross negligence in the performance of a lawful act. And there's 2 elements that have to be proved: that the defendant caused death, and in doing the act that caused death, the defendant acted in a grossly negligent manner. Now, I don't believe there's just the evidence supports that particular theory, because this would mean she was involved in an act specifically involved with those victims that caused their death, and she was not. Where we're at in this case, the only set of circumstances that I think fit in this case is gross negligence in failing to perform a legal duty. And this is what the state focused on and focused their case on. There are 4 elements that must be proven beyond a reasonable doubt. And if even one reasonable doubt exists to any of these elements, they must return a not guilty verdict. First off, that the defendant had a legal duty to the victim. 2, that the defendant knew of the facts that gave rise to the duty. 3, that the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And 4, the death of the victim was directly caused by the defendant's failure to perform this duty. So what duty are they talking about? Well, they're talking about this legal duty. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor so as to prevent the minor child from intentionally harming others, or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm. I've gotten into, in previous videos, my thoughts on this. This is a novel argument. This legal duty definition that exists within the law of Michigan has never been applied in this way, in the way it's being applied here. But they're essentially saying that their legal duty was to care for Ethan Crumbley's mental health and to get him help, and that by allowing him to have access to a firearm while knowing he was mentally hurting and that he was in bad mental health, that they should have seen that there was a potential that he would perform a school shooting. Even saying it to me just sounds absolutely outrageous, because the first thing you have to do is you have to villainize the idea that he would be in a household with firearms. And that has to be such a crazy thing that you would say, okay, I'm going to put a firearm in this house with my child. And with that, I've got to be extra, extra, extra careful. I'm going to start thinking of all these things. Yes, for people that don't like firearms or don't own firearms or don't possess firearms, this is an easier argument to get behind. But for individuals, I myself am not a firearm owner, but I have family that is. I would not believe any of their children are more likely to be a school shooter than my children, right? So for them, assessing the behavior, assessing how the child's acting is not necessarily going to be, to them, it's not going to fall, it's not going to hit differently for them and say, well, I think my kid, because he's exhibiting some behavior that many could very easily associate with just teenage angst, teenage issues, just being a teenager, you're going to immediately jump to and go, oh my God, he could be a school shooter. I better go get him help. And if, again, we'll go over the facts and circumstances that the state's case relies upon to state that they're guilty of gross negligence here, but it's a stretch. But anyways, so causation, right? There may be more than one cause of death. It is not enough that the Defendant's Act made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find, beyond a reasonable doubt, that the deaths were the natural or necessary result of the Defendant's Act. In this case, they're going to explain what that act was. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and the defendant's acts or inactions need not be the sole cause of the harm. So it means it's just got to be a contributing factor, meaning Ethan Crumbley can have other reasons for having done it, but the fact that they didn't get him help and that he was mentally troubled and he was given access to the gun, that is enough to say it was a contributing factor, which would then make them guilty. But there is a big but here. In order to find that the death of Madison Baldwin, Tate Mayer, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting someone was reasonably foreseeable. And it is there that this case hinges upon. Obviously, the assumed set of facts. He was given access to a handgun, although in the case of Jennifer Crumbley, she was not responsible for the firearms. She was not responsible for securing the firearms. And all of the evidence that came in this case was that she believed the firearm was secured by her husband, and that Ethan Crumbley did not have access to it, and that there was no reason to believe. I've saw no evidence that she believed, except we'll go over the one witness that presented some very questionable testimony around this. But there's really no evidence that links her to the storage of the gun. Now, the main crux of the case in this case hinges upon the school meeting and what she knew, what she should have known, and what she did, all in relationship to that meeting and having left him at school and not taken him with her. And it is inside of that meeting that the state's reasonably foreseeable that they are hinging everything on and saying she should have believed at that moment, at that meeting, with everything she knew leading up to that, everything she knew about her son, the fact that a firearm was available or firearms were available within the house, that she should have been on high alert and she should have seen that, yes, he was going to perform a school shooting, and she basically did nothing and let it happen. Again, this to me is where, if this jury is reviewing the evidence, reviewing the law, and understanding what reasonably foreseeable means and what they're suggesting here would have had to have been done, there is no way this jury should come to a guilty verdict. There's just no way. The evidence does not support it. And we're going to go through all of the evidence here. Now, before we do that, we're going to get into the legal definition in Michigan of gross negligence. And it says gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. So these are three things that they got to find. First, that the defendant knew of the danger to another. That is, she knew there was a situation that required her to take ordinary care to avoid injuring another. So again, it comes down to this meeting. They're saying that the circumstances she was brought to the school under, that everything she learned at the meeting would have made her aware that there was a high probability and a high chance that Ethan Crumbley was about to do a school shooting, and that she could have helped and assist in avoiding that from happening. And that's the second factor. Second, that the defendant could have avoided injuring another by using ordinary care. And the ordinary care they're alleging is she removes him from the school and gets him counseling, and that she should have known this. And the third thing is that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. So it's saying that any reasonable parent with the given set of circumstances would have 99 out of 100 times said, I'm removing my kid from the school and I think he's going to do a school shooting. And if you're a parent out there, I am a parent, so I can answer this question. If you were given the entirety of the circumstances that we heard about in this case, would you have believed my son or daughter is about to do a school shooting? And I submit to you, just like her attorney did, no way. No way. No way at all. Certainly not with the timing and the space and the distance between when these text messages that we heard about were happening and the events that were happening and the things that were going on. No way. And that sheet, when you look at the sheet, we looked at this at the end of day 7. It, just like the school officials, that sheet very, very, very easily could have been interpreted like it was, that it was a cry for help, that he was wanting to hurt himself, not others. And I don't think that was unreasonable. They were not aware. There was no evidence presented that they saw those journals that he was writing. There's no evidence that they saw anything on the phone in regards to what he was planning to do. And if there was evidence that they saw that, ignored it, and allowed him to go to school, that's a totally different story. But there was no evidence whatsoever that they were aware of anything like that. And the idea that you would say, hey, they should have been, well, then you're just not a parent and you just don't understand what it's like to parent teenagers, because you're not going to be able to see things like that all the time. You're going to be trying to raise your teenager with the ability to say, hey, I will react when I'm aware things are going on, but unless your role is not to constantly invade their privacy. And if you're believing you're doing a good job as a parent and you're trying to raise them correctly, you're not going to be believing that your child is planning to go in and shoot up a school. It's just not something that's going to be of a natural course. Is it something we know happens? Of course. But there's going to have to be some pretty substantial things coming in, like a direct threat, somebody finding a hit list or something. But the reality of the situation is that just like when you find people unaliving themselves, right? The people that are serious about doing this, and this is what came out, and I don't know why the defense didn't try to put on their witness, but there was a witness the state wanted to call that they didn't end up calling. Well, they were going to call them, but they didn't like the results. And essentially, this witness said that the reality of the situation is the science says that that individuals that do these type of acts, who actually end up doing it, are not going to telegraph it. You're never going to be able to know it's going to happen. It's much like when somebody wants to unalive themselves. If somebody's truly serious about it, you don't know about it until it happens. The people that are doing it for attention and aren't serious about following through, they're the ones that are going to leave a note. They're the ones that are going to leave a hit list. They're the ones that are going to talk about it to everybody. They're the ones that are going to let people know. And the reality is that's because they were never serious about doing it. They just want the attention from when people think they're going to do it. And in the case of Ethan Crumbley, he was obviously serious about doing it. So he didn't let anyone know. He acted normal. He was a manipulative kid who had a goal, and he went and he fulfilled that goal. And there was no evidence in this case, as you're going to see, that was presented that indicates that Ethan Crumbley let anyone know, or that anyone was aware. So let's go through here. So the final theory here is that the state, or the final thing that the state wanted to present to the jury, is that there are two different ways to prove the same crime, and that both are sufficient. We already talked about this. It is not necessary that you all agree on a theory that has been proven. But anyways, we've already talked about there's really only one theory that fits this case, regardless of how the law reads, and we went over that one, and that is in regards to failure to act. So the state begins their case calling Molly Darnell. Now, again, this is important because let's look at what they said she brought to the table. And you can see nothing. Okay. She was shot. It's horrible. This was a witness that was only sole purpose was to inflame the jury. Zero probative value or evidentiary value. Next one, Katie Gibson Marshall. Heard gunshots, smelled gunpowder, located one of the victims, identified and spoke to the shooter, had eyes on the shooter, said that he ended up not shooting her because she stared him down. Again, what evidentiary value was this? None. This was just simply meant to drive home what a horrifying, terrible thing this was. Cammy Beck. Now, this is significant. I will, say this is the first thing that presented any evidence that they needed to establish, which was she testified that in June of 2021, again, and this is actually more of a significant fact for the defense, because she testifies that they sold a Kel-Tec and a Derringer to James in June of 2021. Those were in the house. Those were never used in a school shooting. Ethan had respected all the rules surrounding those. So again, the Crumleys are not going to feel like, because they purchased this 9mm Sig Sauer, that suddenly this is some sort of life-changing event, life-altering event, that this is going to cause them to be on alert. Okay. And she said that James came in and said that he had his eye on it, that Ethan was with him, that she provided him with a trigger lock statement, and a cable lock was also provided with the November 21st gun purchase. And the cable lock is a safety thing that you can put on to make sure that there's a key, keep the key somewhere else, and that way, even if somebody gets their hands on the gun, they can't use it. Special Agent Brandon. So he comes on here now. He assisted in the investigation. He's an ATF agent. He is informed of the shooting. He ran out of the office. The chair was still spinning. Again, that is brought in not for evidentiary value, but for emotional value. He traced the murder weapon to James Crumbley. We already knew this. And here's the thing you got to understand, too, putting these witnesses on. One thing that you've got to understand is all of these witnesses that we're talking about right now, the defense was willing to stipulate to these facts. So in other words, the state did not need to waste the jury's time presenting these witnesses, putting these videos through, because they were willing to stipulate to all of this. He indicated that he watched surveillance video. He helped prepare search warrants, and surveillance video was of the school. That he obtained shooting range videos. He got the purchase information for the Kel-Tec, Derringer, and Sig. He went over the ATF trigger lock statement. He certified that he found the Instagram post by the defendant and her son, that there was image of the Keltec and Sig Sawyer on Jennifer Crumbley's phone. He also made an observation that the weapon that was drawn by Ethan Crumbley on the math worksheet resembled the Sig Sawyer, and that he immediately recognized in watching the videos that the shooter was proficient in firearms. Now, I take umbrage with this fact because, in my opinion, the fact that he was proficient with firearms was not a negative. That actually is another example of the responsible nature of the parents, because they took the time, his father took the time to train him how to properly shoot a gun, how to properly handle a gun. And again, the idea that you would say, well, you taught your kid how to handle a gun is not in and of itself concerning. And once again, you have to look at the culmination of the evidence, and we're going to be going through. We're going to look at every single witness here and look and say, okay, what was the strong evidence that should have given pause to James Crumbley, to Jennifer Crumbley, and said, hey, we shouldn't teach our son how to handle a firearm safely and be proficient in how to shoot a firearm and how to have a proper stance and proper holding of the gun. These are all things that a father, if a hobby is existing between father and son of having an interest in firearms, you would want to teach your son how to handle it correctly. So again, this is one of the first examples of how the state has attempted to take this piece of evidence and twist it and turn it and say, nope, that should have been something that was a checkbox in your favor, but no, we're going to say, nope, look at this kid. He knows how to shoot weapons. Oh, what irresponsible parents for teaching him how to shoot a weapon. Anyways, the next witness that comes on the stand is Edwardrowski. He's a cellular phone forensics and historical cell site analysis expert. He describes his involvement in observations at the high school. He reviewed surveillance footage from the shooting. He reviewed messages between Jennifer and James, between Jennifer and her son, between son and friend. He looked at cell phone data location to identify where all the suspects were during the incident. He reviewed Jennifer Crumbley's communications. He reviewed and helped preserve the 911 call by James. And he also looked for deleted content from the defendant's cell phone and social media. So we're going to see some of those messages that he found and that were presented in the messages that the state believes proves their case. But you're going to see how cherry-picked they really are. So next, Kara Pennock is called, and Kara Pennock, again, this is another inflammatory witness. They call her to testify to the fact that, again, about really unnecessary information, that it costs $400 per month for the horse to be left at the barn. If you're going to own a horse, you got to put it somewhere. That Jennifer would be at the barn 2 to 3 hours per week, 2 to 3 times per week for 2 to 3 hours at a time. So essentially spending 6 to 9 hours at the barn. That's not unusual. Most people have hobbies. Most people have things that they do. They have a son that was 14, 15, 16 years old. He's got his own things that he can do. There's nothing unusual about this. It's just, again, this is a witness that, again, is called in just for the simple character assassination of Jennifer Crumbley. Talks about a Halloween party at the barn that was for parents and their small children who are still celebrating Halloween, which Ethan was not. I have a son that's like 6, he's 18. I have a 14 and an 18-year-old. And I can tell you, when my son was 15, he was interested in going to small little kid parties. And my 14-year-old isn't going to be interested. Now, we also have a 4-year-old in the house. So they've still, once he came along, they got interested again and going in attending some of these things just for the purpose of being there to witness their little brother having fun. But in general, you're not going to bring a 15-year-old around 6-year-olds, 5-year-olds, 7-year-olds. I understand why he wouldn't have come. And if they're demonstrating trust in their son, that they say, hey, you can stay home, play your video games, do your stuff, take care of yourself. Said that Jennifer called her son weird and an oopsie baby. Okay, big deal, right? A lot of moms feel their kids, especially their sons, get a little weird when they get into their teenage years, because that's just a weird time. They get interested in things and they get doing things, and they're smelling differently than what they did when they were a young little baby. There's lots of things that are going on in their life that during that time, there's going to be friction between mothers and sons at times. It's not unusual too, as well, that kids are taking on various different interests, and you may find something weird that's going on for a period of time. That, again, character assassination, nothing here. Why was she called? Now she testifies that Jennifer shows her the math worksheet. She told her that day that the school counselor had recommended he not be alone, and that they were going to have to get Ethan into counseling. And Kira Pennick had sent her messages in regards to saying, "Hey, bring him down to the barn." A lot of kids that are troubled and depressed and are having problems, they when they get around horses, it helps them. Again, the state twists this around, but what this really shows is that she is reaching out to her friends. She's reaching out to her support when her son is struggling, and she's not doing it in a way to say, "Oh my God, I think my son's going to shoot up the school." She's like going, "Oh, he did this. He's reaching out," because the mindset was, the tone of the conversation at the school was, Ethan was potentially wanting to hurt himself, and Jennifer was very upset by it. So she reached out to a friend. That is a common response by many parents, to reach out to family and friends and seek counsel and seek ideas and seek just a place to say, "Hey, help me here. My son is having problems." But again, an example of the state just simply bringing a witness in for purposes of character assassination. At this point, there's really no evidentiary value of anything at this point that is going towards reasonable foreseeability. All right, so next one is Sean Hopkins. Now we get into the counselor, and this is the crux of the case right here, this witness. But this is also really one of the most important witnesses for Jennifer Crumbley as well. He's the counselor at the school. He brings in and talks about an email he received from one of Ethan's teachers that said he was looking at bullets in class. Now, this guy goes, and of course, in my kid's school, if you're looking at bullets in class, they're going to suspend you. They're going to take action for the simple fact that you're doing something that you're not, that isn't, you're basically on your phone. You shouldn't be. Two, obviously they're going to be saying, "Hey, he's looking at bullets. That's not something we really want him doing in school." In the tenor and the climate of the way things are, we're concerned about that. But most importantly, he's getting disciplined here because he wasn't on target and he wasn't focused in class, and we can't have him on his phone in the middle of class. But what does he do? No discipline. He just voicemails Jennifer Crumbley. He doesn't ask for a callback. It's just a voicemail to inform her this is what Ethan was doing today and go forward. So again, we would consider Sean Hopkins a well-trained school counselor as a reasonable person. So right now, he's not calling her. He's not throwing him out of school. He's not suspecting a school shooting. Or that he's a school shooter in the making. Nothing like that. So why would Jennifer Crumbley assume that either? Now at 11:30, Ethan Crumbley is looking up a violent video, this violent video was of a video game, which kids, I know my sons will watch video games, what they call their playthroughs, but this was a video game playthrough. Once again, it was in class, and then he also had drawn on his math test. So this got forwarded down to Mr. Hopkins, and he decided he was going to call the Crumbleys and ask them to come in for a meeting. He sat and counseled with Ethan. Now, the state's takeaways here is that he expected the shooter would be taken home, They would obtain immediate counseling, and that Ethan Crumbley couldn't be left alone, and he was allegedly never told critical information. At least that's what the state says. Now, what the state leaves off here is the fact that Sean Hopkins, if he believed that Ethan Crumbley was potentially a school shooter in the making, if he believed that the parents were in any way neglectful, he has a mandatory duty to report that. And he did not do that. In fact, as comes out in his own testimony and in Jennifer Crumbley's testimony, he never asked Jennifer Crumbley to take Ethan Crumbley home. He, in fact, said, what we're concerned about him, we want to support him, and we don't want him to be alone. So it would probably not be a good thing to take him home and leave him at your house alone, and probably wouldn't be a good thing to take him to work and leave him alone in a conference room. Best thing for him to do is be around his friends. He's feeling down. He's clearly upset. He's, there's been some strife at home. He's upset over his grades aren't where he want him to be. He's struggling with some things. We need to get him some support. We would like you to get him counseling within, 48 hours. Have at least reached out to a counselor and had a counseling session set up for him to be able to go see this counselor. We're going to follow up with that, but we don't recommend you take him home. It wasn't until hindsight kicked in. It wasn't until 4 children lose their life and Ethan Crumbley does a school shooting that suddenly Mr. Hopkins says, oh my God, I messed up here and I had the opportunity to send this kid home and I didn't. So now he becomes incentivized to off put the blame to the Crumbleys and not himself. And again, this to me is not evidence of it's not any evidence of that it would have been reasonably foreseeable that this would have happened. In fact, it speaks to reasonable doubt because of the fact that Sean Hopkins' takeaway was that it was okay for him to stay in school, regardless of whether he knew about 7-month-old messages. I don't think that would have changed his opinion. He would have just said, oh, sounds like he's having the time of it. Grandparents, that was already told to him. The fact that they bought a gun, okay, keep that away from him when he gets home. There is nothing that would have led them to believe that he was going to do a school shooting. Ethan Crumbley had given no indication he had a gun. He had not said anything about doing a school shooting. He had not led anyone to believe that was going to happen. So it was not reasonably foreseeable at that moment that was what was going to occur. And Mr. Hopkins concurs, and he's a trained counselor. Again, this case ends right there. But let's talk to, whoops, shoot, got too far ahead here. Nicki Jack. All right. So let's talk to Nicki Jack here. He's the next witness in the case. Dean of Students, responsible for discipline. What does he bring to the table? Well, he was aware of that worksheet. He was aware of the unaltered and the altered worksheet. He agreed with the assessment that Ethan Crumbley shouldn't be left alone. He, in hindsight, believed the defendant seemed irritated. State says, well, he was operating short of information. But again, as I said, I don't believe that information would have changed anything because, again, the state is saying that 7-month-old text messages about an alleged ghost that was in the house, information that he was aware of because it was shared that he had lost a grandparent. It was shared that he was upset about a friend leaving. The gun information was left out, but Mr. Jack wouldn't have said, oh, I think he's got a gun in the book bag because there was no indication he had the gun. There was nothing written on that math worksheet that indicated that gun was in the school. No one had gotten a hold of his phone and looked at a video on his phone. and seeing that. This is not like a situation where they see this video and they present it to the parents, and the parents say, nah, leave him in school. We don't think he's going to do a school shooting. There was not 1 ounce of evidence that any school shooting was coming. Again, Mr. Jack gives an honest, reasonable assessment of the situation, and that is that he would not have foresaw that a school shooting was going to happen, just like neither Mrs. Crumbley nor James Crumbley would have foresaw that as occurring. And everybody in that room felt they were dealing with a kid who was potentially crying out for help, and that the risk was to himself, not to others. So, next witness that comes on, Sgt Joseph Bryant. Now, he is, in my opinion, key to understanding why this case turned into a case against Jennifer and James Crumbley. He was one of the detectives that was at the substation when they walked in. Remember, they walked into the substation. If they came there looking for their son, who allegedly they don't care about, they show up there. They didn't go home. They didn't hide out. They didn't flee. They went to the police station looking for their son, trying to get information because they cared, asserting their son's rights, letting the police know they wanted to get him an attorney. And the police, again, we saw the video. It's on my channel, video of the interview. Now, he says her demeanor, and said she didn't really look at the drawing. Counselor said we could take him home. I really wish we took him home. And she admitted that she had bought 100 rounds for $56 at the gun range. So she admits that. Again, no evidence of reasonable foreseeability. The only thing that she says, which I think is a statement that says more speaks to innocence and her being not guilty than it does to guilt, which says, counselor said we could take him home, and I really wish we took him home. Meaning, the counselor gave that option, but they discussed it, and as it was discussed with the counselor and Mr. Jack's testimony, that there was a discussion, and that it was determined that the best place for him was to be in school around his friends. And he is, again, I believe this gentleman was off-put by her demeanor in the sense that she was the one that asserted that her son needed an attorney, and that upset him, and that pissed him off. Next witness comes on is Andrew Smith. This was Jennifer Crumbley's boss. Now, they use him to say, again, and this was a completely spurious argument, that she had claimed that she couldn't get off work, which was, again, on cross-examination, that was softened up, and it was pretty much completely eliminated as being of anything of significance, because it was made clear that Jennifer Crumbley never said she wouldn't take him, but that the counselor never directly asked that he be taken out of school, and that the conversation circulated around what was best for Ethan, and that the counselor acknowledged that he said he thought the best thing for Ethan was to be around his friends and not be alone and not go home and and that they wanted to keep him in a positive place because they were worried about self-harm. But he testifies that they have a flexible work schedule, that she could have taken her son to work, that the defendant told him she needed to get her son counseling. It felt like she was failing him. Now, this is after that meeting. So, again, this to me speaks more to the fact that Jennifer Crumbley is a parent, a vigilant parent who cares about her son, who feels like, oh my God, I'm not being there for my son. That's a common thing when you find out, hey, I really thought my son was in a better place than he's at, and you're finding out that, hey, he's thinking about harming himself. It's going to weigh heavy on a parent, especially a parent that loves their child. And that's what she was exhibiting to her boss. He says that she didn't need to attend the afternoon meeting on the 30th. Now, he said that she had texted him the mass sheet, at the time. I guess this was prior to the shooting. And then she'd also texted him following the shooting, I need my job. Please don't judge me based on what my son did. And that the defendant had deleted text from him. Now, again, a context thing. You look at that and you go, why would you say that? Well, listen, she understood that in this case here, right, any parent, her husband is working, is not gainfully employed. In terms of he's working for DoorDash, he's self-employed essentially. So the benefits are running through her. She's a steady income. She's worried, obviously, that the optics of this situation could lead to the company deciding we want to part ways with you. The only way she's going to be able to afford to defend her son, right, and potentially herself if that were to come to pass. But in her mind, for her to afford an attorney and get her son the legal help that he needs, she's going to need a job. So to me, there's nothing wrong with her sending that out. And it's a very valid, reasonable assumption that her job may be concerned and could decide they want to fire her. Now, this individual they call Amanda Holland is interesting because they call her, she's not even a friend. She's a coworker. She's an acquaintance at work. And they use her as kind of a individual who, because she's a mother and has kids, although she has kids that are much, much younger than Ethan. They're in like elementary school age. So she really doesn't have any relatability to having a teenager, but she's called in more or less to give a critique, a motherly critique. She's a coworker. She says that the defendant told her that her son was lonely with his friend being gone. So basically, I guess she was talking about things that were going on in their house and fights and stuff, which is, hey, listen, my son had a friend move. I would never thought my son was going to be a school shooter. He was upset for a while when his friend moved, and I was there. I talked with him and tried to entertain him and tried to get his mind off of it, and he moved on past it. But I would have never thought in a million years. Now we don't have guns, but I would have never thought in a million years, hey, my son's going to go shoot up a school because he lost his friend. It just would not have come in. Now, she also testifies that there was a fight the night before the shooting that Jennifer Crumbley had come in talking about, and that they had locked the son out of the house. Now, that's an interesting thing. I've never locked my kids out of the house. I wouldn't do that by practice, but I don't know what the circumstances were surrounding that. Maybe it was just a cool-off period. The defendant told her that the son was hearing things around the house within the year of the shooting. And again, this comes back to, as Jennifer Crumbley explains, Jennifer Crumbley was simply talking about the fact that they thought their house was haunted. And this lady, again, context is key. Just like her attorney says, this lady takes it out of context. But that's ultimately what this lady brings in. Showed her son's drawing on the math sheet. When she got back from the meeting, the defendant agreed with her that the drawing was scary. Again, her thought was, again, hindsight, after shooting, they're looking back and saying, oh, that was scary. But she does acknowledge that prior to that, she was in agreement that it looked like maybe her son was intending to harm himself. She also had offered up that she would have taken her son home. Again, she wasn't at that meeting. I think a lot of this is all said after the fact. So it is a dangerous thing when you are going back after an event like a school shooting and trying to assess decisions, actions, and things that were done. There's a danger that you're going to let the emotion of that event take over, and it will reframe the memories. I think that's what's happening with her. Next, we have Detective Adam Stoic. He testifies that he served a search warrant on the Crumbley's house, that there was an open gun case on the bed with an ammunition box. There was no lock, no cable. Gun safe was set to 000, and he goes over pictures of the search warrant. He took a bunch of pictures inside the house. Sgt Matthew Pasji, he is the one that cuffed Jennifer Crumbley. He says that he brought her out to the car, put her in the back of his car, and they put a video camera in there of her in the car. Said that she didn't look at the images, that the defense said she didn't look at the images on the math sheet. The defendant corrects Pesky when she said it was a .45 caliber used at the school, tells him it was a 9mm. The other one is a .22, I think. Said son had no gun range, no phone. He's never exerted anything. Mental issues. Here, my biggest fear was that he turned the gun on himself. You don't keep guns in your car. And she shook her head no. So now, admittedly, they're saying that the fact that she had knowledge of what guns he would have used, they were trying to insinuate that she maybe had some prior knowledge. But the reality was her husband had called her and told her the 9 was missing. That's why she knew that. This, again, nothing here. Says that she didn't look at the images on the math sheet. Again, okay. We don't know what she saw. And if she didn't look at the images on the math sheet, that's very potentially possible, because there was the altered math sheet that she might not have closely looked at it. Again, if you look at it, you see it enough and you go, it looks like he's drawing himself having shot himself. That's what it looks like to me, if you glance at that. And again, you're just not going to jump there and go, oh, he's going to become a school shooter. I mean, it's like beating a dead horse, but you got to beat that dead horse because that's the reality prior to this whole thing. It's just so out there that a parent is not going to believe that's what's going on, unless you have something that really directly ties in, that he mentioned something to a friend or she finds something on his phone that's talking about that. And none of that existed or is presented, as you're going to see here. So Lieutenant Sam Marsbon testifies that he drafted the search warrant. He responded to Oxford High School. He identified 2 of the victims. He showed a picture off of the shooter's phone that the defendant said the son needed to suffer. She obviously is upset, seized phones from defendant and her husband, and the defendant resisted giving up her phone. Again, she explains that when she testifies. And I would be the same way. That phone has everything in it. So numbers, everything. And phones aren't cheap. It's just like, oh, go down and buy a new phone. No, it's a lot of money. But the bottom line is, besides even saying that her son needed to suffer, I mean, that's an unfortunate thing to say. But I think that, in the moment when you're finding this out, yeah, you're going to say, my God, he's clearly that's not the individual that she thought she knew. So she's reacting in emotional times and emotional moments. So again, nothing that goes to reasonable foreseeability there, right? David Hendrik, he testifies. He's a fugitive apprehension team. So this is where they're going to try to say that she had a guilty consciousness. Now, here's my problem with this. And again, this is another example of the state having no evidence. In a case like this, you would not, wanting to flee would not be a demonstration of guilt, because this is not a case, when you're in a negligence case, this is not a case of intent. So this is a case of no intent. In other words, you're not intending to commit a crime, but what you did was reckless, that could have possibly caused injury or harm, and you just simply didn't pick up on it. So after the fact, the mere fact that you're fleeing isn't indicating that is consciousness of guilt. This isn't a whodunit. This is we know what happened. We know what your role was. And this is just simply an assessment of everything that led up to the event that occurred. So how you act after that event, I'm sure many people would be very afraid when you find out you're getting charged with multiple counts of involuntary manslaughter. The whole world hates you. How do you think you're going to process that? You're probably going to hide. You're probably going to possibly consider fleeing. You're going to try to consider all options, because you're sitting here thinking, Jesus, what the hell? How did I end up charged in this situation? I didn't intend to do any of this. I don't think I'm guilty of any of this. I had no idea what was going on with my son, but the whole world isn't going to care, because clearly they're coming after me and they're wanting to put me in handcuffs. But that is not an indicator of whether or not it was reasonably foreseeable or not that this would have occurred, and that she would have had knowledge of it being foreseeable. Nothing. So this is a complete nothing burger. This is a complete waste of time. But anyways, what he testifies to is that they used cash to avoid detection. explained how to avoid arrest, use cash to avoid detection, stop communicating. The defendant's vehicles left at the extended stay. On scene, hundreds of officers at 11111 Bellevue. So this tells you just the staging of this. To me, this is more helpful to the defense, and the idea that says this is how ridiculous they were acting and the police were acting. And this was the extent that the police were willing to go to try to make the Crumbleys look bad and look like criminals. They next call Luke Kirtley. He offers nothing, right? He just talks about how he observed the defendants. He called 911. The building gets, again, this is nothing. Like, it's a waste of time. In fact, the defense, I'm pretty certain, stipulated to this. Now, Corporal David Shaw, multiple agencies present on the scene an hour and a half before they entered the area where the defendants were, and they pound the door with a 35. I mean, again, this proves nothing. Nothing. There's no evidentiary value here. Now, Brian Maloche, this is the star here, right? Because this is the crux of the case. We've heard the counselors, and now this is the one that if the jury believes his witness and believes what he said, they have the potential here to have their smoking gun. Known defendant since high school. He was having an affair with the defendant, so that makes her look really bad. Now, he didn't come in and admit that right away, but it was admitted under cross-examination. But here's the important part of his testimony. Now, it is absolutely thrown into question here because Brian Maloche deleted all his text messages prior to the evening of the 30th. So he is testifying based on memory. Now, the problem is under direct examination, he admits that he has had memory problems. In other words, he has a condition that causes him to have problems with remembering things. Not exactly the guy you want holding your smoking gun, but here we go. Here's the smoking gun. Says that she texted him saying she was going to the school, afraid he's going to do something dumb. That he asked, "Where's the gun?" And the defendant said the gun was in her car. Okay. My opinion here is he is, again, an individual with issues with memory. This is a situation where he hears the wrong thing. What he claims he heard is that she was afraid he's going to do something dumb. No. I think it's more likely that she said, "I'm going to the school because my son has done something dumb." She sends him the picture of the sheet. He says, "Where's the gun?" Because just like everyone else in that moment, he is not thinking about, and again, she's communicating to everyone that the school counselor believes, and that they believe they have a situation here where her son might be wanting to harm himself. So a discussion occurs about where's the gun. She says it's in my car, or at least something along those lines. Although in this case, there is no evidence to back any of this up. So it's even more possible that because it was within a day or two, I think it was 2 days before the shooting, 3 days before the shooting, she had taken him to the gun range, and probably he had asked, there was discussion about that. And my belief is that he's transplanting that memory from the gun range and was being told the gun was in the car to saying to himself, well, yeah, she said something about the gun being in the car. And the police begin the questioning of, again, at first, he doesn't tell the police any of this. Over time, when the police, as it comes out on cross-examination, over time, the police apply pressure, and he suddenly remembers this. And of course, the defense went to great lengths to emphasize that, point out the fact that they threatened his job. They threatened to expose the affair he was having. They threatened to expose details that not only was he having an affair with Jennifer Crumbley, but that they were essentially operating as a swinger couple, having an affair on their spouses, bringing other people in to the affair, stuff that he absolutely did not want out on the street, but it ended up coming out because the defense took the gloves off and had to go after him and show that he didn't have a good memory, show who he actually was, and show what the police were willing to do to him, try to get him to tell the story that they wanted. Now, he also talked about, said that these were messages that were verified on the phone that she had texted him, on the run again and we're fucked. Again, nothing that doesn't go to reasonable foreseeability. Nothing. That part does not. As I stated, they're on the run. They're scared. They believe they're about to be arrested. Any reasonable person would be afraid and so would say things like that. Now, obviously, if this jury believes that she messaged him, and this is one of the situations, this is the strategy of the state, they are giving the jury a reason to convict her, because essentially, if the jury, so inflamed by the earlier witnesses, so inflamed by the surveillance footage, so inflamed by the pictures they saw in the medical examiner who testifies right after him, we'll get to that in a minute, so inflamed by all of this, they're looking for a reason. This guy gives it to them because, again, there's a lot of doubt as to the veracity and and how accurate his testimony was. But it really doesn't matter if they believe he made that she told him, I'm afraid he's going to do something stupid. He asked where the gun is, and she said it was in her car. And they come back and later on prove, hey, that gun was never in the car. That gun was in the house. So why is she lying to him about this? Why is she deflecting him? It is that moment right there. If they believe that sequencing of event and that conversation occurred, there is the evidence that she believed it was foreseeable that he was going to do something stupid that included a gun, and she took no steps. She left him at school. She didn't search his book bag, and she walked out of that school, went back to work with her head in the sand. However, I do not believe the evidence in any way, shape, or form backs that up. I don't think the discussion at the school backs it up. I don't think I think this man, again, after being under intense questioning by the police with a threat of this affair being exposed and his job being taken from him and his retirement pension being taken from him, which he was very close at the time he was being questioned to getting, that he eventually says, fine, I'll tell you what you want. And as the defense brought out, the more the police officers, when they were questioning him, used a technique where they would put information into a question and they would ask it, and he would at first give an answer saying that wasn't true, and they would ask it again and again, and over time, as they asked the same question with the answer essentially loaded in, he would eventually agree to the question, and then he would begin adopting the information that they were including in the question. It's a technique that police use that unfortunately adds unreliability in the statements, but it's effective for the police who want to be able to say, no, this guy came up with it on his own. In fact, they used it in the Tyrone Tucker case, and I've seen how disastrous that case has led to. Why police officers do it, I have no idea, because these investigations should be about finding out what happened and collecting evidence and following the evidence. But again, when police officers get challenged, when people assert their rights, the human being side of a police officer kicks in and they get mad. So the next witness is William Creer. He was the medical examiner, wasn't the next one. But William Creer, he photographed 111111 Bellevue, sees $6,617 in cash. This is the area they were staying in. Phone was smashed prior to arrival. Clothing, underwear, socks, phones powered off. Pictures taken of them off, not backlit. 3 stashed areas of evidence away from each other in separate locations. Again, this is all information because again, afraid of the situation. None of it goes to the core issue of reasonable foreseeability. Now, defendant, this is what the state says she knew. So this is the evidence right here as presented. Defendant's knowledge of her son. Kira Pinnock says defendant said he was weird, nothing positive, never said anything positive about him, and said he was a Nipsey baby. Amanda Holland said he was lonely, hearing things around the house, failure as a parent. Messages to mother of Ethan Crumbley's friend has been acting kind of depressed. Now, those messages are weeks and months previous to when this incident happens. Messages from sons concerning signs that we're going to go over. You're going to see what these alleged messages were that were 7 months old. After the shooting, in-car interview, and what they're saying here is that you can derive from the fact that she's lying to the police that she understands that she was understanding that she was neglectful and she was trying to cover that up. That's what this is inferring. He's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. And again, I bet you she really felt that way. But the police are saying that these statements from these areas, messages from son in regards, well, we'll get into what those said. The message to the mother that he was upset that Ethan has been acting kind of depressed in regards to the son leaving or his friend leaving. Amanda Holland, the friend from work, and Kira Pinnock, the lady at the barn. In the car interview, says, I never even thought he would have any mental issues. He's never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid back kids. That's probably a very accurate way she felt about him. I mean, he's never done anything. He's never done anything bad. And that's what the school said. That's why the one teacher that locked eyes on him couldn't believe it was him. He had no record. He had no disciplinary record. And then Brian Maloche says he's never done anything wrong. So, again, now the defendants, let's see here. So, conflicting statements, meeting at the school and of the drawing. So, she sends the drawing to James, Kira, and Andrew. I think that's, and this is before the shooting, I think that's that shows she was concerned and cared about him. Again, the discussion is surrounding him potentially harming himself. Messages to James, call now, emergency, I'm very concerned, right? Why is she concerned? Because she thinks that her son might be wanting to hurt himself, might be getting suspended from school. Kira Pinnock says she said that she was told that he can't be left alone. Andrew Smith said that she told him she needed to get him counseling. All things that came from the counselor. Amanda Holland agreed with her that the drawing was scary. The defendant's trial testimony thought her son was trying to send her a message, a little concerned. Situation interview, school didn't seem worried about it, and he said Ethan Crumbley's more than welcome to stay at school, or he could go home, and I really wish we had taken him home. Again, it comes to the reasonable foreseeability, comes to exactly where their thought process was. The school is saying, we think it's him wanting to harm himself. Jennifer Crumbley concurred with that. They're talking about a plan to support him. Again, there's nothing in any of this that says that she would have reasonably believed her son was going to go shoot up a school. In-car interview. I didn't even look at them that closely. Well, now that when I was at the substation, I looked at them more closely. They're a little disturbing. Well, they're very disturbing. Look what he just fucking did in reference to the math assignment. And Maloche says, very nonchalant, but the paper they showed us had all these things scratched out. So, again, I think the in-car interview, that statement says, she's looking at it. It speaks volumes about her opinion of her son. Yes, she thought he was a little weird, but he's a good kid. And when you listen to her testimony, she tells the story of a family that's going along. They have traditions. They spend a lot of time together. They're joking around. Yes, there's some signs that when you look back at this thing and you go, wow, that must have meant that. But in the moment, there was nothing definitive. There was nothing that was there that would have said, this means he was going to go do what he did. And the reality of it is, the science behind this is that these kids that truly do something like this, they don't talk about it. They're not going to be outward about it. They're just going to plan it. They're going to do it. There isn't a preventative. There isn't a way to prevent it. And that's why the defense attorney has said this is like putting a Band-Aid on a gunshot wound. Because the reality is, there was nothing that anyone could have done to stop this event, including maybe the only thing would have been to keep firearms out of his hands. But in our country, in that community, law-abiding citizens are allowed to own firearms. And he and his father, to them or to his dad, he believed it was a hobby. And it's a side effect, unfortunately, of the freedom to own weapons. So unless you want to take away weapons entirely, this is something that is a potential hazard that could occur. But to come and say, well, the parents should have assumed this because they were gun owners, that any time their child does something weird, we have to act swiftly and believe you're going to be the next school shooter, is a ridiculous standard. And this is why I believe the vagueness, the voids for vagueness attaches to the way they're applying this law. It doesn't apply to the law, but it applies to having it done this way. And I don't know if that is a way you can apply the void for vagueness doctrine. I imagine you probably can. Creative lawyer can figure out how to apply it, or at least get an appeals court to listen. But there are problems here. So defendant's statements regarding the storage of gun: said gun was in her car, drove with the gun to the range, no lock on gun, returned with gun in the car, said James locked the gun when he got home. Trial testimony: James' responsibility to get the gun out of the car. Substation: where was the gun at? Hidden. James flew home and he's like, I had hidden the gun and I told him where I hid the bullets. In-car interview: asked where she kept the gun in her car and responded shaking her head no. We had the string lock on it, came with in that case. Everything was secured, not loaded, bullets stored separately. Oh my God, that was a text message. Again, when it comes to storage of the gun, it's very clear that that was the responsibility of her husband, James. She went to the range 3 days before this happened. Given the fact that the case, which we saw her carrying into the shooting range, was laying open on the bed, would indicate that James had that hidden somewhere. He went to that hiding place. He opened it up and gun missing. If this is James Crumbley's trial, we might be having a different discussion as far as one of the ways they can come to conclude that he might be responsible and be found guilty of involuntary manslaughter. Because if he did secure that gun and he was irresponsible in securing that gun, we don't have to prove the mental health angle. We can just say, would it be reasonably foreseeable that a child gets a gun and is playing with said gun or using said gun, that it could cause the death of another? And it is. Doesn't mean that they have to foresee a school shooting in that case. But in this case, since the main hinging theory is that, well, she didn't really have control of the wet firearms, but it was here that we see this sheet and we should assume then that a school shooting was going to occur. Since she would have assumed the gun would have been secured, okay, then again, we would not assume she would be thinking he has a gun and he's about to shoot a school up. Okay, that just would not be where one would go with that. All right. So, defendant's statement is trying to distance herself from responsibility for the gun. So they're trying to, say that she was aware that the gun might not have been secured, but they said trial testimony, they wanted to get the gun. My son did a lot of research on it. I guess when I was out shopping, they went to look at one. James is responsible for storing the gun. In the car interview, we take him to the gun range. Our hobby, we go to the gun range. That's what we do. James flew home and he's like, I had the gun hidden. I told him where I hid it. Substation review discusses buying ammunition. So sometimes I don't know where I hid the bullets. So again, Mom and Sunday, Instagram says, Mom and Sunday testing out his new Christmas present. Ethan and James R. Crumbley both got handguns this week, testing them out at the range. Again, none of that proves that she was responsible for the gun. The fact that James flew home after the shooting and he didn't go to Jennifer's car after the shooting would be proof that he believed the gun was stored at home where he hid it. So I think we can end any idea that they're going to be able to say uh, Jennifer Crumbley should have assumed the gun wasn't secured. Now, here is perhaps evidence that I believe, I don't know why this was admitted. It's hearsay, number one. It should have never been admitted into this case because Ethan never testified and they were not allowed to confront these statements. It says, I have zero help for my mental problems and it's causing me to shoot up the fucking school. Horrible, but there is no evidence that Jennifer Crumbley saw this. Now, if she saw that and did nothing, we have a clear-cut case here. First off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Seeing the shooting. Secondly, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed this to now. So yeah, I'm going to prison for life, and many people have about 1 day to live left to live. So again, this is demonstrating clearly that he was planning to do this, but this tells you right here, he's writing in a private journal. He's come to this conclusion. He's not bragging to friends. His parents had no idea this was written. Why this was brought in, I have no idea. But this is meant to inflame the jury. This is meant for the jury to look at this and say, why didn't they do more? And what could they have done more if they didn't know about this? So the next thing here, deleted messages, entire Facebook message thread deleted from phone and messages were on the run. Helicopters not sure where to message you and we're fucked. Message of drawing, the gun is gone. So are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Kara Pennick, okay, I'll bring some out later. Just had to go to my son's school and meet his counselor. Shit day. Can't be left alone. I still plan on doing the lesson. Everything's okay. He's just having a hard time. So there you have it. He's having a hard time. This goes and reads directly to the idea that she certainly does not believe he's going to do a school shooting. And if she did, I believe she'd do everything in her power, considering how she acted after the fact, and considering that she reacted as this has ruined not just his life, but her life. She was cognizant of the fact that her and her husband were potentially going to be sued. There's no way in the world that this woman would have walked out of that school and thought, I'm just going to leave my son there to go do a school shooting. It's absolutely ridiculous. It's asinine. Okay. And again, it has to be foreseeable, which means she would have had to have been aware that this was a possibility. And I believe if she thought that was a possibility, she would have done everything in her power to prevent it. Now, this tells you all of the timeline. I think this is fantastic for the defense. Look at this. This is a breakdown, mental breakdown, April of 2021, paranoia, March of 2021, bowls flying, demons, grandma died, son's upset. As she explains in her testimony, all of this was because of the fact that he thought the house was haunted. He's also saying things in relationship to trying to get out of having to clean the house, straighten up his room. Again, it is not out of the ordinary. The kids will say things and do things to try to get out of the responsibility of helping around the house. The idea that we're going to sit here and say that messages from March and April are related to a situation that occurs in November when there's nothing else. Remember, they have all these messages. They have everything. Nothing got brought in. Okay. And then all they had, and then not only that, but they buy these guns in June. So nothing happens with those guns. He doesn't try to bring them to school. He doesn't say, I'm going to go do a school shooting. And as a result, these parents are not believing that the introduction of the Sig Sauer 9mm into the household is any type of life-changing event. It doesn't become an event until the shooting happens. And then it becomes an event of note. So this, to me, the state puts this up, but I think this pounds home the distance between these events and how the relationship of these events to each other is tenuous at best. And I don't believe you can sit here and say that this mom is going to be thinking about something that happened 7 months ago when she's sitting in that school office. I just don't believe it. I don't think it was that significant. And I think this, what she described and how she described these incidents, and it'd be interesting to hear from Ethan himself, but he said it in a sentencing hearing. Don't blame anyone else. It wasn't anyone else's fault, and no one else could have known. And that was an honest statement that I think he made, and that was honest about everything that occurred. So they get in here and they say, well, again, they're trying to act as if the activity or the buying track phones, we're on the run, we're fucked, we got money out. None of this proves anything. They go over all the different events that occurred leading up to the arrest. Says what Jennifer didn't say. Things Jennifer knew but failed to disclose to the school. So this is ridiculous. March 9th, 17th, and 20th, text about a demon. The demon throwing bowls, clothes flying off the shelf. Why would that be in her? Like, she's not talking about it. He's not talking about it anymore. The 18th, regarding her son being worked up and giving him melatonin. Clearly, they were having disciplinary problems. He was upset. This is 7 months ago. If it's not repeatedly happening again, which it's clearly not because it's not being discussed in the messages, it's not a significant fact that she's going to be thinking about 7 months later as something that has to do with what's going on at that moment. Her son previously asked for help and to go to a doctor, and she laughed at him. That was said in text messages to his friends. And again, he should have been required to testify so they could have confronted him about that. But he wasn't. He didn't come testify because he was taking the fifth. This should have never come in. There were multiple guns in the home. Son gifted a gun days before shooting. Guns looked identical to the one in the graphic one drawn that morning. Gun was accessible to the son. There was ammunition that was accessible in the home. His son was proficient with the gun, and his son was locked up. Look, none of these things would have changed how this counselor would have looked at things because the picture that was drawn appeared to be of him harming himself, and that's how they took it. And they would have just said, make sure he doesn't have access to a firearm. And I'm sure James Crumbley would have made sure that firearm was locked up and secured away from him after the meeting they had at the school that day. But we don't know because, of course, nobody made it back to the Crumbley house to deal with that. Now, here is the picture in question. Okay. Here is the picture in question. And when you look at this, it says blood everywhere. The world is unalived. My life is useless. The thoughts won't stop. Help me. It's certainly when you look at this, okay, when you look at this picture, when I look at it, if I glance at this, it looks to me, when I think of Ethan Crumbley, it looks like he drew a picture of himself shot. Now, obviously, some might say, well, the gunshot wounds are like here and here. But when I'm looking at it in a moment, assessing it, I'm thinking to myself, no, he's just drawing a picture with blood coming out of his head that it would look like he's a kid, he's drawing and he shot himself multiple times. Now, remember, now here the state, of course, shows the resemblance. Again, it means nothing if they're looking at this as a cry for help that he's going to hurt himself, right? And when you look at it in that context, that's how the trained counselor was looking at it. Now you look and you say, wait a minute, look at this. Look at these 2 bullets that he put in here. Somehow this is supposed to have, I guess, resonate that this was a school shooting. Says, so here are the messages, right? And keep in mind, these are 7 months before. They said the thoughts won't stop. Says, okay, the house is now haunted. Some weird shit just happens, and now I'm scared. I got some videos and a picture of the demon. It is throwing bowls. I'm not joking. It fucked up the kitchen, and I'm just going to be an outsider for a while. Can you at least text back? Can you get home now? There's someone in the house, I think. Someone walked into the bathroom and flushed the toilet and left the light on, and I thought it was you, but when I came out, no one was home. There's no one in the house, though. Dude, my door just slammed. Maybe it's just my paranoia. But when you're going to get home, I finished picking up the room. I cleaned until the clothes started flying off the shelf. This stuff only happens when I'm home alone. And none of this. This is a stretch to believe that any of this indicates mental illness. And since the house was a fixer-upper, as she explained, they both, everyone in the family believed they might have had some sort of ghost in the house. That was a running joke. That was a running thing that they both thought. And these things are happening, and they're having problems, and they're wanting to have him, clean his room and straighten up his room and do different things. And he's talking about this. Some of this might even be legit, that he legitimately believes the house is haunted. But none of this is going to land. You're not going to go take your kid because he thinks the house is haunted and goes, I'm taking you to the emergency room and having you brought onto a mental health floor. And clearly after the fact, nothing more is said about this, at least not to them. There's no more text messages that come out of any significance. So again, I come back to it. Why would this be on her mind 7 months later? To her, it was not significant. To the state, cherry picking this stuff, looking at it in a vacuum and trying to make a case against her, suddenly it is. April 4th and 5th. This is text messages to a friend. This is not to his parents. Defendant's son. Like, I hear people talking to me and see someone in the distance. I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I'm having some bad insomnia and paranoia. I need help. I was thinking of calling 911, but then my parents were really pissed. Like, I'm mentally and physically dying. Look, you have to understand. When I hear this, he's a kid that's clearly having issues behaviorally. He's getting into some trouble. He's telling his parents, I think I'm mentally upset. I think I'm mentally breaking up and whatever. And they're kind of taking the approach like, okay, Ethan, sure you are. I understand. You're just upset because you got your phone taken away. You're just upset because you're getting consequences. Settle down, calm down. Just take a deep breath, buddy. And he gives him whatever pill he talked about. Now, again, there's nothing more after this that happens. To talk about. Now, here's pictures of them at the gun range that they show. Defendant's knowledge. Knew he was distraught. She said, I love you from the son, which was abnormal and odd. Knew he was looking up bullets. Knew he was watching violent videos. Knew he was proficient with guns. Knew he was previously in crisis and asked for help. Knew his dog died. Only friend left and grandma died. Moody and depressed. Listen, none of this on this sheet rises to the level that she's going to think he's a school shooter. There was nothing happening. There was nothing that occurred besides that sheet that pops up, which again, all involved. And again, the only thing that that school counselor, although even if they found out about it, and again, her attorney talks about this, but even if they found out about it, it would not have rung as unusual that he got a gun. It would have just said, secure that gun, keep it out of his hands, and make sure he doesn't use it on himself. Because there is no indication from the people in that room that they believed that this was going to be a school shooting. It would not have changed their opinion, I don't believe. And this jury, I think, is going to have a better understanding in the outside world of that fact. They're not going to immediately just assume because guns were owned and stored at that house that rises to the level of, hey, we're going to assume that this kid is the next school shooter. I just do not believe it. Defendant statements. No, I don't. I mean, of course, I look back after all this happened, and I've asked myself if I've done anything differently, and I wouldn't have. That's what she testified to. I featured that in some shorts. Took his gun away. They're saying she misspoke. Okay. And to me, that's a greater example of just how ridiculous this case is and the lengths they're willing to go. She clearly misspoke when she was saying, I took the gun range away and I took his gun away. They were talking about the phone and she said gun because they're talking about gun range and she's nervous and she's on the stand. I don't want to say that I'm a victim because I do not want to disrespect those families that truly are the victims on this, but we did lose a lot. Yes, they did. And yes, they are a victim. Okay. And if this was being properly viewed, then her and her husband are a victim in a way. Now, they didn't lose a child in the sense of to death, but he might as well be dead. He's in prison for the rest of his life. Never to walk out of those walls again. Everything they thought they knew about him, out the window. The kid they thought they knew died that day in that school as well. Any individual that walked back out of that school is their son only in flesh, bones, and skin after that fact. And then on top of that, of course, they've taken considerable financial loss. They've lost their freedom. They may lose the next 75 years of their life, maybe their whole life behind bars. So yeah, they've lost a lot. I don't think that's an unfair statement. And I don't think it would be insensitive for them to say that. When considering this. Like I said, that is the state's case. Again, it all hinges on Brian Maloche. That is the only evidence of any foreseeability that she foresaw any of this happening. Everything else is character assassination, is that she's a bad person. Yeah, the police officers testifying that they just didn't like how she was acting and like how she was reacting, which is ridiculous because none of these police officers have dealt with a situation like this ever. They have nothing to frame it against or compare it against or understand how someone's going to react when they find out that their child is a mass shooter, killer, whatever you want to call it. No one's going to handle that well. And the way you're going to handle what you're going to do about it is all going to be different. And the witnesses that they presented in this case, as we just went through, using the exhibits that the state used in their closing argument, are very, very weak. So we're going to end this by listening to Jennifer Crumbley's attorney, who's going to speak to us. And I believe say some very, very, very important things. So give me a moment to cue that up. We'll take a listen and then we're going to end this thing. And again, I think if you're following along with this, if you're taking the emotion of the moment out of this and you're looking solely at the evidence and at the law, I don't see how you can agree with me that this jury has only one verdict to deliver tomorrow, and that's not guilty. Give me a moment here. Let's cue this up. All right, so here we go. We're back here, and let's listen to this first clip here.
Cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection...
All right, so, what she's saying there is very, very important. I want you to think about what we just went through. I want you to think about text messages that they're taking that are 7 months old with no messages in between to connect them. I want you to think about that. I want you to think about the way they brought in evidence that is all what I would call subjective evidence. They brought in an individual who was a acquaintance at work to express judgments about Jennifer Crumbley's decision making that day, to offer up opinions and offer up information that was meant and designed simply to inflame her. They bring in her horse barn owner simply to say, hey, she's spending $400 a month on her horse, plus feed and other expenses. Again, context. And that's what you're going to hear Shannon Smith talk about. But it's very important that you understand what she just said there. To me, that is a very, very important point that I'm very, very glad she made. Because that is the crux of the case. And I'm hopeful that landed with the jury. Because if it did, then it should be very clear what the verdict is they should return.
It felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Miss McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Miss McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial...
All right, so we're going to move on to the next clip here. Give me a moment. We're going to move on to that. Give me just one moment. All right, so we're back. So we've got this queued up here, and we're going to listen. This is the final clip we're going to listen to. This is our going home clip. She's going to touch on reasonable doubt, and she breaks down exactly what this jury needs to consider and what you need to consider when you're considering this case and what verdict should be returned in it and whether or not reasonable doubt exists. But one reasonable doubt, that's all you need to, and again, to the sole issue, the main issue being, was this reasonably foreseeable that this would have occurred? And in my opinion, there is no way anyone is going to be able to say beyond a reasonable doubt that they believe Jennifer Crumbley absolutely would have thought or knew that a school shooting was going to be an outcome here, and that she would have thought that that's what it was, given the fact that we know that we have school counselors in the room who are trained. We have a disciplinarian principal in the room who's trained, that everybody is going towards self-harm. She leaves that school. The tenor of the conversation with everyone is about, he's struggling. We need to get him help. We need to get him counseling. James doesn't race home and say, let me race home and go check the gun. Nobody believes he has a gun in school. Nobody believes a school shooting is imminent. It's not until an active shooter alert goes out that they realize, oh my goodness, holy cow. And again, Jennifer even says then, I didn't think he was going to shoot people. I thought he was going to shoot himself, or he's got a gun and he's running around outside the school. She thought he might have walked home and got the gun. It's still not landing that it's possible that he had a gun with him in the school at the moment that they were in that meeting. So, anyways, let's listen.
Case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. Place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Edwardrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw, so he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted.
That is, to me, says it all. They have very little context for the very little evidence that they have submitted in this case. But I think one of the things, because Brian Maloche is such an important witness, what she brought up in the cache discussion is important to understand, because in that case, they had messages. In that case, he was reviewing messages that were available. The most important testimony that he offered, which was as to what she said when she was heading to the meeting, which he claims to have remembered her saying that she was going to the school because she was afraid he might do something stupid. Okay. that him remembering that, having been asked to recall that, after the shooting already occurred at the police station, with a threat over his head that if he didn't recall things in a less favorable light to Miss Crumbley, that he was going to be exposed for the affair he was having and for the things he was doing, that it became clear that just like he misremembered the cachet incident and thought it was about something nefarious and about deleting messages, that it's very likely that what she really said was, I'm heading to the school because my son's done something stupid. That makes a ton more sense. Now, when you review remembering that after something like that happens, after the school shooting happens, okay, there's a little bias entered into the memory. But because you deleted all the messages and you're not certain what was said, and he's telling them, I think she said something about him doing something stupid. And then the police officer says, well, was it that she was going to the school, or could it have been he was going to the school because she said she was going to do, well, it could have been, was it? Well, yeah, I guess it was. This man is very open to suggestion. And that was very apparent, as the defense attorney pointed out in her closing, later on in the closing, that he was very susceptible to influence, having his testimony or his statements influenced. So with that, you take away Brian Malocious' statement, you look at the entirety of everything. You look at the fact that statements in March and April were made in regards to something that was a running theme, a running joke, if you may, a running discussion in their household, that their house was haunted, that they had a demon or a poltergeist at the house. And you look at the context of that. You look at the context that they were having some sort of disciplinary issues. Clearly, it was circulating around him cleaning his room and straightening up his room, that he was flipping out. He wasn't handling things well. And he's then coming to them and saying, I need help. I'd like to go see a doctor. And they're saying, yeah, sure you do. Okay, yeah, all right. You're just upset because you're getting things taken away and you're on restriction. Okay. And your grades aren't where they're supposed to be. Just calm down. Everything's going to be okay. And then guess what? Everything must have been okay, because there's nothing. There's no more messages. There's no more discussions. They buy the Kel-Tec. They buy the Derringer in June of 2021. Nothing else happens. He doesn't take those to school. He doesn't make statements to them. His friend isn't going to his parents and saying, hey, I think Ethan's going to shoot up a school. Yeah, he's talking some stuff to his friend. He's exaggerating. Kids do that. But that friend clearly didn't take it serious enough that he went to his mom and said, hey, Mom, Ethan's saying this. Talk to Ethan's mom. I'm really worried about him. I'm really worried he's going to do something crazy. I'm worried he's going to hurt himself. No, it was just discussions between two friends talking about concerns and things that they had in regards to, their parents. But it wasn't, again, it didn't rise to a level to where he went and told his mom, or he went and tried to tell. And again, if those were the things that had happened, the state would have every right to have made a case that said these parents were ignoring things. But none of that happened. And they brought a case against two parents for the sole fact, I believe, that they were mad because they asserted their son's rights at the police station an hour after the shooting. And these police officers believed that they should have let their son talk to them, and that they should have been given full, unbridled access to their son. Remember, if they would have done that, Mr. and Mrs. Crumbley would have been at the police station with their son, sitting there, allowing him to be questioned, as many parents have done. They would have been eventually greeted with the idea that said, hey, we need to serve a search warrant on your house, it would have been a very cooperative, it would have been a very cohesive thing. And they would have essentially said, if you co-sign us doing what's necessary to get your son convicted of this offense, then we'll leave you alone. But when they said, no, we're not going to do that, we want to see a lawyer, we want to talk to a lawyer, we want to make sure that all the I's are dotted and the T's are crossed. That was a step too far. That was just a path crawl, a step too far, a line crossed, that these detectives felt, okay, fine. You want to be against us? You want to make our life difficult? We'll show you how we can make your life difficult. And then they didn't like mom's attitude. They didn't like the fact that they were not cooperating. So they came in, they busted them. And who do they throw in the handcuffs? And I wish her attorney would have made a bigger deal about this, because who goes in handcuffs? Not James. I don't believe I saw James. Maybe I'm wrong on that, but I do believe that was the testimony in court, if my memory serves me right. James was not in cuffs. Jennifer Crumbley's asking, why am I in cuffs? They were humbling her. And police officers will do that because they felt she needed to be humbled. They felt she needed to understand what it meant if you're going to continue to protect your son who just shot up a school. And if you're going to keep protecting them, then we're going to make your life a living hell. And they went way far on that. Because they didn't just make her life a living hell. They figured out how to charge her. They figured out how to vilify her. And they figured out how to say, you know what? You're going to go to prison potentially for the rest of your life, but we're going to destroy your life nonetheless. And that's what they've done in this case. And again, the scary part is that any parent could find themselves in this situation. If this is allowed to stand, when you have prosecutors that are willing to overreach, redefine laws, reinterpret laws, and go out and charge parents without having evidence to do so. If you got to stretch this much, if you got to bring in this much innuendo, if you got to try to inflame the jury in order to get the outcome that you want, that's probably a sign that it's not the right outcome and it's not a good case. I'll leave you with that. As we move into tomorrow, well, it'll be today, I guess, when you guys are watching this. But I believe there's only one verdict. You put in the comments what you think. But after watching this 7-day-long trial, having consumed all the testimony, I haven't looked at anything other than what the jury saw. I didn't get to see, obviously, some of the things. Again, I consumed it without being inflamed, without having to see the horrific nature of these crimes. I saw it the way the defense would have intended it to be seen, but we didn't see any of that. We did hear some of the testimony, and it was horrible. And I feel terrible for the families that have had to endure this and who had to lose their children. I cannot imagine what that means. But when we apply the law, when we remove emotion and we look at this and we say, do we really believe these two parents are the villains that the state of Michigan has made them out to be? That they sat here and ignored the fact that their son was going to shoot up a school and let him do it? No. I don't think the evidence shows that at all. I think what it does show is it shows that Ethan Crumbley was a troubled young man who hid it well. His parents underestimated what they were dealing with. The counselors at school underestimated what they were dealing with. And there was no criminality here besides Ethan Crumbley himself. And the individuals that missed it, that didn't catch it, that misinterpreted things, their sentence shouldn't be prison, but it is a lifetime of regret and guilt that will follow them around for the rest of their life. But besides that, That is all they are entitled to. And Jennifer Crumbley should be found not guilty tomorrow. Now, her husband, when he goes on trial, we're going to listen to that whole case. Again, there is another element to his case that might make him a slight bit different, and that is what evidence the state will have as to whether he secured that weapon or not. But if I'm not even certain that there's evidence that's a strong case to be made, but again, that's not what she's on trial for here. And I don't believe that is a strong, beyond a reasonable doubt piece either with her. I think there's a lot of evidence to suggest that she had nothing to do with securing those firearms and therefore shouldn't be held responsible for that. So I've eliminated that. So the only issue it comes down to is whether or not she believed at that moment in that office with the belief that her husband had secured the firearms. The firearm was secured at the house. As she's looking at a picture that's thrown in front of her, did she believe her son was drawing a picture of a school shooting? Or did she believe he was drawing a picture that reflected self-harm that he intended for himself? And if she thought it was self-harm, she's not guilty. And I believe that is what the evidence shows. I believe there's a strong reasonable doubt as to whether or not, as to that fact. And I believe she will be found not guilty tomorrow. Put in the comments what you think. Until then, I'll see you in the morning. I'll see you in court to listen to the jury charge. Then we'll be on verdict watch, and we'll go from there. So until then, guys, let justice prevail, and I will be talking to you soon.